Hi, and welcome to today's webinar. I'm delighted to be presenting another session on behalf of IPSE, the membership body supporting contractors, independent professionals and freelancers. My name is Luann Wise, and I'm a chartered marketer and independent consultant. I've run my own consultancy business for 6.5 years. I work with clients and I also write books, courses and speak at events. Today's session is on the hot topic of GDPR and how it affects use of social media. I've hit the record button and you will get a copy of the recording and the slides and a blog version of the script after the session. But first, a disclaimer. GDPR is a very large and complex piece of legislation, and I'm not a legal practitioner. I have scripted the content for today and it's been reviewed by a law firm. However, you should still seek your own legal counsel for any specific requirements you have. At the end of the session, I will invite questions. However, I can't offer legal advice on the GDPR, so I may need to follow up with further resources. This session is taking place live on the 10th of April 2018, and the information I'm presenting is correct at this point in time. Thank you for being here today. In this session, we're going to cover quite a lot, and the slides are quite copy heavy, but it's a heavy subject. So we are going to be looking at an overview of GDPR, key definitions within GDPR, some data processing and data protection principles, the EU-US Privacy Shield. Then we will talk specifically about GDPR and social media management. So the General Data Protection Regulation, known as GDPR, comes into force on the 25th of May 2018. It applies to all businesses, no matter how large or small. It applies to everyone marketing or selling to individuals and organisations within EU, and also to organisations outside the EU if they are offering goods or services to EU citizens or monitoring the behaviour of EU citizens. GDPR is mandatory. We're less than a year away from Brexit now, but you can't ignore GDPR, as the UK government has recently published its draft data protection bill, which is very closely aligned with GDPR. And following Brexit, this will ensure that an equivalent to GDPR remains in force in the UK. If you're not compliant, the ICO could issue a fine of up to €20 million or 4% of your worldwide turnover for the previous 12 months, whichever is higher. Affected data subjects can also bring their own financial claims. And there are step levels within these fines, but it's not just about the financial consequences. There are criminal sanctions for officers, directors, partners and senior managers. At the moment, these sanctions are limited to fines rather than prison sentences, but the liability is personal. But it's also about trust. Business today is built on trust. We buy from businesses we know, like and trust. We recommend businesses we know, like and trust. And as such, the impact of brand and reputational damage can be far greater than any financial penalty. GDPR replaces the current data protection regulations, which came into effect in 1998, well before any social media platforms were launched. Much guidance has been published by the Information Commissioner's Officer, or ICO, who are responsible for upholding data protection regulation in the UK. The ICO advised that GDPR is a living document, so there is more advice to come. And it was the Data Protection Practitioners Conference in Manchester yesterday. In her speech, Elizabeth Denham, the UK Information Commissioner, said, "There's never been a more important time to be involved in data protection. You all have a role to play in advocating the correct use of personal data in a world where it powers so much of what makes our economy, our home life, and our public services function." She also said that the 25th of May is not the end, it's the beginning. So here's the GDPR situation as of today, April the 10th. Some definitions. Some key definitions that we need to understand when it comes to GDPR. And that's the controller, the company or person who decides how and why personal data is processed. The data subject, which is an unidentifiable living individual. It's all about personal data, which is any information relating to a data subject. And then processing is doing anything in relation to that personal data. We have a processor, which is the company or person who processes personal data on behalf of the controller, and a recipient, which is the company or person to which the personal data is disclosed. So just to clarify again, what does constitute personal data? It's any information related to a natural person or data subject that can be used to directly or indirectly identify the person. It can be anything from a name, a photo, an email address, bank details, posts on social networking sites, medical information, or a computer IP address. It doesn't matter whether a person can actually be identified from the data, e.g. the IP address. Under the GDPR, it's only relevant that the information relates to an identifiable person. That's a subtle but important difference between the current Data Protection Act and GDPR. And it's also worth stressing that work-related emails will be personal data under the GDPR if they allow a person to be identified. Okay. Processing. Data processing. Whether an organisation acts as a controller or processor isn't always an easy question to answer. Just because you're using another organisation's data to provide services to them, you can't assume you're acting as their processor. Quite often, outsourced service providers can be data controllers in their own right. But processing means any operation or set of operations performed upon personal data or sets of personal data, whether or not by automated means, such as collection, recording, organisation, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination or otherwise making available, alignment or combination, restriction, erasure or destruction. Lots of words and terminology to get your head around with this topic. But whether or not you do anything with the data you collect, it is still processing and comes under GDPR. All data controllers and data processors need to comply with data protection principles. Data processors have not previously been required to comply with these principles under the current Data Protection Act, but will be required to do so under GDPR. So let's have a look at these data protection principles. Businesses must process personal data lawfully, fairly, and in a transparent manner. Businesses must collect personal data only for one or more specified, explicit, and legitimate purposes. Businesses must ensure personal data is adequate, relevant, and limited to what is necessary. Businesses must ensure personal data is accurate and kept up to date. Businesses should not keep personal data for longer than is necessary. And businesses must ensure appropriate security of the data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage using appropriate technical or organizational measures. These 6 principles are really key. But alongside these data protection principles, there are 6 alternative grounds for the legal processing of data under GDPR. Applying any one of these means satisfying the lawfully requirement of that first data protection principle. Now, these 6 lawful grounds are consent, that the individual has given clear consent for you to process their personal data for a specific purpose. Or it could be contract, that the processing is necessary for a contract you have with the individual. For example, you need a postal address if you're delivering a product ordered, or because they've asked you to take specific steps before entering into a contract. The third possible ground is legal obligation, that the processing of the data is necessary for you to comply with the law, or vital interests, that the processing is necessary to protect someone's life. Public task, the processing is necessary for you to perform a task in the public interest or for your official functions, and that the task or function has a clear basis in law. And then finally, the sixth ground could be legitimate interest, that the processing of the data is necessary for your legitimate interest or the legitimate interest of a third party, unless there's a good reason to protect the individual person's data which overrides the legitimate interests. It's quite a lot, isn't there, to get through? But going back to the legal ground of consent, there is a much higher standard of consent with GDPR, and the definition of consent is that it should be given by a clear affirmative act establishing a freely given, specific, informed and unambiguous indication of the data subject's agreement to the processing of personal data relating to him or her, such as by a written statement, including by electronic means, or an oral statement. Which means no more opt-outs, no more pre-ticked boxes. There needs to be complete transparency about the purposes of processing data, and we need to keep records of that consent being given. It must also be easy for someone to remove their consent at any time. So when requesting content, the more you can split out your options with separate tick boxes, the better. And link those options through to a privacy policy that explains your purpose and grounds for processing. Please do seek legal advice on updating your privacy policy. So, why is this all relevant to use of social media? Well, many of us are using social media to generate awareness, and we're posting links to content whereby we're asking for an email address in exchange so that we can continue to market them. We're also using social media to nurture relationships. The EU-US Privacy Shield. So at this point, it's important to note that many of the online services, the social media platforms as well, we use as small business owners and marketers are based outside of the EU. And this is where there is a EU-US Privacy Shield framework which becomes important to GDPR compliance. The EU-US Privacy Shield framework was designed by the US Department of Commerce and European Commission to provide companies on both sides of the Atlantic with a mechanism to comply with EU data protection requirements when transferring personal data from the EU to the US in support of transatlantic commerce. Now, US organisations, including the social media platforms, can self-certify and commit to this framework agreement, which underpins their protection of EU citizen data entrusted to them. The screenshots here show that LinkedIn, Facebook and Twitter are all actively listed on the EU-US Privacy Shield, which means we're all good to continue using them for business. Facebook owns Instagram and WhatsApp, so they are okay too. If you need to look up any other organisation, any other software tool, any other social media platform, there is the link to check it out on the Privacy Shield. So far, so good. GDPR and social media. So the good news is that as far as consent and data use is concerned, when it comes to GDPR and social media, is that effectively it's covered by the terms and conditions and the privacy notices of each of the social media platforms. I expect over the next few weeks we will be receiving communications from each of the platforms. If not via email, then certainly a pop-up box when we log in to advise about policy updates. Now, the area for caution when it comes to social media and GDPR is extracting personal data from the platform and storing it elsewhere within your business. For example, it's only acceptable to take an email address from social media, hold it on a CRM or use it in any email marketing activity if you can justify doing so via one of the 6 legal grounds and provided you comply with the data protection principles. It's not impossible, but it could be quite tricky to achieve. You can continue to message via the social media platform where you've made the connection, liked or followed, but you can't move the communication to any other marketing channel unless you can satisfy those legal grounds and comply with the data protection principles. So let's have a look at the platforms themselves, and I've included here links to the information pages on LinkedIn, Twitter and Facebook. Now, the content of these pages will change over the next few weeks, so please do keep an eye on them. But what they say primarily is that the social media platforms are data controllers, and they have responsibility for ensuring compliance with GDPR. And as previously mentioned, LinkedIn, Twitter and Facebook are certified under that EU-US Privacy Shield. LinkedIn's website says that by the time GDPR becomes effective, all members will have the option of opting out of allowing use of their demographic data in ad targeting. Members will control this from a new advertising settings page. GDPR will, however, have some effects on their products, such as the marketing solutions, the sales solutions, and the talent solutions or the recruitment products. Twitter's website also says that they are working towards GDPR compliance, and they will be updating their privacy policy, which will be available to review before the 25th of May. As with LinkedIn and Facebook, when you upload your own data to create a tailored audience for advertising, Twitter becomes a data processor. You are the data controller, and you're responsible for ensuring you have the legal grounds to process the data before transferring it to Twitter. Again, on Facebook, if you are uploading your own data and using it for custom audiences, you are transferring the role of data controller to Facebook as the data processor. And that's the key here, is the use of your data and transferring that responsibility. Now, whenever you're creating ads on the social media platforms, you are asked to accept their terms and conditions, and they will also change to comply with GDPR. In short, when a company is providing personal data to any advertising platform, for example, in the form of an email list, they will need to have the right to do so under GDPR. When advertising for lead gen purposes on social media, you'll need to ensure that there's a suitable disclaimer and a link to a privacy policy on any form you use when capturing data. No pre-ticked boxes for obtaining consent. Where you need to exercise the caution is taking that personal data out of social media and using it, and being cautious when you're collecting data in exchange for content such as downloads. You need explicit consent before you can continue to market. If you're promoting products via social media, however, at the point you capture the personal data, you are processing it for contractual purposes. So again, it's about understanding these different principles and the grounds for processing. But the good news is that working within the social media platforms post 25th of May is GDPR compliant method of marketing, so long as the platform you're using itself is compliant. Their compliance makes the process easier for you, but check out the platform. You will need to justify one of the 6 legal bases for processing and comply with the data protection principles. Because many of us are using social media for lead generation, I will mention email marketing briefly, as social media is often used for list building. Under GDPR, it is a mandatory requirement to be able to prove that the recipient had given valid consent, and a double opt-in procedure is a highly recommended and well-established process of proving that. Double opt-in simply requires a subscriber to tick a box to receive marketing material, and they then receive an email asking them to confirm their email address. Double opt-in is not a requirement, as it's possible to prove valid consent without following the double opt-in procedure. However, it is a really good way of providing evidence that consent has been obtained. Just one last area to cover when it comes to social media and GDPR right now, and that's the use of social media management tools, which I know in the past week has experienced a few issues with Facebook's API changing and some restrictions around that. But in terms of GDPR, here's the information from Hootsuite, which is the management tool that I use. Like the social media platforms themselves, they have a statement, and their website says, Hootsuite is a data processor of content generated, requested, or published via its supported platforms in accordance with the instructions our customers give us through our services. Because our customers control how their content is collected and used by them, our customers are, in legal terms, the data controllers of the content that they process through our platform. Hootsuite is its customers' data processor of that content. And for more information on the types and categories of data we and our customers collect and process, see their privacy policy. And there's a link there to their GDPR information on their website. So if you are using any social media platform or management tool, check their website for GDPR updates and also that EU-US Privacy Shield. Now, if you are outsourcing social media management, then you will need a data processing agreement with any suppliers. There must be a written contract when one business processes personal data on behalf of another business. Written contract. And the bullet points on this slide and the following one are what needs to be included as a minimum in that contract. It needs a summary of the subject matter of the data, the length of time that the processing will continue, the nature and the purpose of the processing, the types of personal data that will be processed, the categories of data subjects whose personal data will be processed, a statement of the obligations and rights of the data controller, that the data processor must only act on the data controller's documented instructions, and all of the data processor's personnel who access the data must be subject to appropriate confidentiality obligations. And there's more. The data processor will comply with the requirements in the GDPR regarding security measures and encryption. That the data processor must assist the data controller in dealing with requests from data subjects, dealing with data breaches, and conducting impact assessments. The data processor must delete or return at the data controller's choice all personal data at the end of the contract or when the need for processing ceases. The data processor must provide any information the data controller requests in order to demonstrate compliance with the GDPR and to allow the data controller to audit and inspect the data processor's compliance. The data processor must not delegate the processing to a sub-processor without the data controller's written consent, and then only on the basis of a written agreement which contains similar terms to all of those I've just listed. In addition, a data controller is only permitted to use data processors that provide sufficient guarantees to implement appropriate technical and organisational measures in order to meet the requirements of the GDPR and protect the rights of the data subject. Now, if you are a social media manager and you haven't yet received a written contract from your client, then I would strongly recommend updating your contracts to clarify your client's role as data controller and your role as a recipient of personal data and a data processor. There must be something in writing to protect both parties, because if you don't, then in theory, both parties could be fined up to 10 million euros or 2% of annual global turnover, whichever is greater. Now, there's only a few weeks to go, so please do put some time into your calendar to prepare your business to be compliant under GDPR. We're recording this, I've written this, so I know there's a lot to take in. I assure you that spending a couple of hours focusing on it does start to make everything become a lot clearer. You do need to seek your own legal counsel, but be aware that law firms are super busy on this right now, so don't leave things last minute to get advice. We are 44 days away from GDPR coming into force. Yeah, there's work for all of us to do, but hopefully this webinar has helped to reassure those of you that have started to prepare that most of the requirements are actually best practice and will not hinder business activities. It's so important to clearly understand the data you hold and collect for your business, the alternative grounds for legal processing of data under GDPR, and to maintain records. But going back to my introduction, if you did manage to hear it, trust is a key currency in business. And I believe the transparency around getting consent and sharing the purpose of collecting data can only be a good thing. GDPR compliance will ensure that only those who wish to receive marketing communications on your list, which hugely minimises waste in terms of time and resources. As consumers become more aware of GDPR, and I think the consumer campaign is about to be launched or has been launched in the last few days, they will be more aware of the information they share with organisations. So we may see a reduced volume of available data, but that's fine. The remaining data should be more focused, targeted, and valuable as a result. I've used this quote because I believe that as business owners and marketers, let's focus on what we do have available and focus on delivering great customer experiences. There's lots of quotes around right now that in the next few years, but it should always be the case, that customer experience is the competitive battleground. It's where businesses are won or lost. So let's be careful with data, focus our efforts, demonstrate best practice, everything should be fine. If you are looking for further information, the best place to go is directly, I believe, to the ICO website, the Information Commissioner's Office. They have plenty of information on there. They've got links of 12 steps to take and checklists. So that really, I believe, should be the first port of call. Now, unfortunately, that's I can't answer legal questions, but if any of you do have questions, perhaps more social media related, start popping those into the box for me. The next webinar with IPSE, my next webinar, I do one of these a month, is on the 14th of May. And on the 14th of May, I will be talking about how to nail social media in just 10 minutes a day. So it's 1 o'clock. That was 30 minutes, quite a lot to take in 30 minutes. So I will just check and see if there are any questions coming through. Some people are asking about other platforms, Pinterest, Snapchat, etc. The best thing to do is to, for yourself, check on the EU-US Privacy Shield. All the information is on there and you need to check that out for yourself. Okay. What's the difference between giving advice as a consultant versus law questions? This is a great question because actually, as a marketing consultant, I am being asked to advise on this, but I personally feel that it is law. It's a legal issue. So I'm not trained in the law, so I don't feel comfortable, and I believe that that's where you should go to the solicitors to do that. It's not something I'm trained in. So there are lots of people offering advice. My advice is it's a legal issue, so go to the legal experts. If I'm asked about this by my clients, I'm making sure they're all aware of it. I'm making sure that my contracts are updated, but it's certainly something that I'm redirecting the questions to the experts in this area. Okay, a few thank yous coming up. So apologies again for the sound at the beginning. I will try and edit that out of the recording before you receive it. If you do think of any questions afterwards, I'm quite easy to find on LinkedIn, Twitter, social media. If you search for Luann Wise, drop me an email. My contact details will be on here. And good luck with GDPR compliance.